What's up, everyone? Welcome back to the channel. Let's talk about it. And in this video, I want to share my experience going before the Court of Appeal for Ontario. If you guys haven't already, please hit that subscribe button. I applied for an appeal to the Court of Appeal for Ontario for this restraining order and court cost that Justice Michael Gibson of the Kitchener-Waterloo Courthouse put in place. I'm convinced that I'm dealing with Canada's most corrupted family court case in Canadian history. And I think it's pretty evident, and it's far from a complex case. All this Kitchener-Waterloo Courthouse did was give a piece of paper to an unhinged ex-girlfriend and an incompetent lawyer. To be honest, still to this day, I still think he got his license out of a cereal box. Let's be honest. I get dragged through family court on a restraining order application never signed. Trial schedule endorsement form never filed. I've lost count on how many documents this lawyer has commissioned without his client's signature. You know, when I say I'm dealing with Canada's most corrupted family court case, it's pretty evident. When you got judges blatantly lying on endorsements, giving statements that can't be backed up by any evidence or facts. You got judges who went behind my back and deleted a 10-page endorsement down to one. You know, if anyone from the public did that, we would be charged with forgery. We would be looking at a penitentiary bid. You got this Justice Martha Tweedie, who caused 18 months of unnecessary and prejudiced adjournments, and then took it upon herself to fill out the applicant's, do the counsel's job, and fill out the applicant's trial schedule endorsement form, which I reference in every video. That's Family Law Rule 17 Sub Rule 11, clearly states that parties must fill out this form, fill it out, serve it, and file. And this lawyer, John David Ekpenyong, he can never do that. If you guys go on Canly and you search this lawyer's name, you can see what I'm talking about. I'm still dealing with this lawyer, this psychotic lawyer, who's now admitted to harassing me, stalking me. He's threatening me, and no one wants to help me. You know why no one wants to help me? Because nobody wants to go over this family court's, this trial judge's endorsement. Justice Michael Gibson, who overheard this trial. This judge is the only judge in Ontario who has his credentials from the Canadian Armed Forces. He's a military judge. And this is the problem I'm facing. I would love to be a fly in the wall in this courthouse, in the trial coordinator's office, or in the chambers, because it just, to me, if I were to guess, this judge, that was all calculated to have this judge selected for my trial. A trial I had no business ever being in. You know, I was told on February 6, 2024, that my trial is going to be the following day, February 6th and February 7th and February 8th. You know, this is a tactic used by courts, from what I've heard from support groups, that the courts and judges will do this. So individual self-representatives like myself don't have time to get support from people to attend the court. And I feel like that's exactly what they did. They set me up for failure. It's a disaster what I'm dealing with. And, you know, I feel so frustrated because I have a cat right now who's really sick. And you know what? I can't even afford to take care of that cat because of this psychotic lawyer, John David Ekpenyong, submitted a fraudulent bill. This guy dragged me through family court on a meritless application. And these judges all collectively failed to apply the rules. They ignored my submissions. They ignored the rules I referenced. It's common sense. You shouldn't, the trial coordinator's office was instructed to schedule a trial without the trial schedule endorsement form. It's a rule. You know how many rules were ignored and disregarded blatantly from this court? I'm still dealing with problems with this court to this today, and it should be no surprise that I'm frustrated. So I went before the Court of Appeal. I filed a motion for an extension of time, and that was heard before Justice Lisa Favreau, who overheard that appeal. And she just sided with Justice Gibson's endorsement, you know. So it was a disaster. I followed everything. I could tell you guys right now, this lawyer, John David Ekpenyong, he filed his materials 30 minutes the day of before this appeal, unsigned, uncommissioned, and his materials were accepted by this judge. It was what I've seen firsthand would deter anybody from wanting to deal with the courts. And I just want to go on with my life, but I can't, because this lawyer, John David Ekpenyong, he submitted a fraudulent bill of cost of $160,000 that I thought for sure this judge would have questioned. He did in his endorsement. He kind of called them out on 3 items that were straight up bullshit. And he still entertained that fraudulent bill. And he ordered me to pay $60,000. And 72 days after that court order, this lawyer exercised generally the last resort and filed a garnishment and blindsided me. It is now what? June 26th, 2025. My bank accounts have been frozen since September 6th, 2024. The Waterloo Region Police refused to investigate this fraudulent home insurance bill that my ex received a $10,000 check for. The Halton Region Police refused to investigate this lawyer for threatening, stalking, harassing, submitting fraudulent documents, and perjury. They don't want to investigate. The police are refusing to enforce the law. You have this prosecutor's office in the Kitchener-Waterloo courthouse there, where Jason Lim was instructed, an assistant crown attorney, was instructed to stay the charges. And who did that? I've reached out to recently to the deputy prosecutor, the top prosecutor in Kitchener, Miss Sethi. Sorry, it's the Sethi, the top prosecutor. I've asked for her help. She's refusing to get back to me. The Law Society sat on a complaint for 3 years with this lawyer, and they refused to investigate this fraudulent bill, and they're still refusing to do it. Chris White, Ari Cashton, they basically ignored my main issues with the complaint with this lawyer. And who else was there? These judges. These judges involved in this case created 2 monsters and gave them the impression they can get away with abusing the courts, and they can get away with submitting fraudulent documents. This lawyer, I just can't make this stuff up, and I really wish I was. And again, I have nothing to gain to mislead anybody watching this video. I got nothing to gain to lie. And the problem is this endorsement from Justice Gibson, that everyone is looking at that like this judge made no mistakes. This judge, you know, I've had to consult with different lawyers about this, and you know, it's the question is why would he risk his reputation and his license to railroad me? Well, I don't know, but he did. He did. He made statements on that endorsement that cannot be backed up by evidence or facts. He said that we cohabitated. I was a spouse. We were common law. None of these things ever happened. This judge said I emailed her, I called her, I breached my temporary restraining order. I was not a tenant. All the evidence and exhibits submitted showed the complete opposite. This judge made comments about me, saying I was rigorous, calling me bad, saying I was a scorched earth litigant. No, I wasn't. These things are not true. And I really want the audio recordings of this trial to be public, so the public can hear what really happened behind closed doors when they railroaded me and gave me less than 24 hours notice that this trial was going to start, because they knew exactly what they were doing. They scheduled Kitchener's top judge, the only judge who has a military background, a Canadian Armed Forces background, to listen to a case that was rigged. Witnesses were caught lying. They submitted fraudulent documents. They admitted that one of the witnesses admitted her daughter lived there. They paid rent. Whereas my ex admitted on paper and lied under oath and said she never rented her basement. It's just straight up bullshit what I'm dealing with. And that I'm still dealing with. Okay? You guys want to rob me? You want to give me a court order and pay costs that were never paid, hours that was never worked? Fine. Let me at least make payments. But this lawyer, John David Ekpenyong, refuses to do that. And I'm going to be getting into a video of 100 or 50 emails of psychotic, harassing, stalking, threatening emails from this lawyer. And shame on the Law Society for protecting this lawyer. And shame on everybody for allowing these two to get away with what they got away with. So let's just get into this video. Don't mean the introduction to be that long, but it's like, why did I file an appeal in the Court of Appeal? Two judges, Justice Martha Tweedie and Justice Gibson, made errors of law and they made errors of facts. We can include three judges if you want to include Justice Bingham, who put the temporary restraining order, who heard John David Ekpenyong lying under oath for the first time and telling me to shut up. And if you guys haven't seen those emails, I'll share them with you because he was caught lying to that judge. And then he tried to gaslight me in the email. This is how psychotic this lawyer is. He tells me in an email that I never told him to shut up at court, showed him the transcripts. I'll share that with you guys. All three of these judges, court staff included, disregarded many rules and laws in my case. They undermined that I was a self-rep who knew some of the laws and rules of the family law, okay? Right off the hop, these judges disregarded, especially the problem is this Justice Martha Tweedie, okay? This was, I believe, her first case. This was the judge who refused to release the audio recordings where she is heard potentially in a major misconduct that she's covering up. She went as far as blocking out almost 2 pages of transcripts of what can be seen as a serious misconduct. And I think the public deserves to know what this judge is covering up, what these judges are covering up. Rule 2 is the interpretation, right? So you got primary objective, you got you got 3, A, B, C, you got 4, you got 5, A to F. And this is basically the primary objective. You got dealing with cases justly, duty to promote primary objective, duty to manage cases. This judge never did that. She caused unnecessary and prejudiced adjournments for 18 months until she decided to step outside of being an impartial judge and fill out a form that this lawyer never did. A trial should never be scheduled if the trial schedule endorsement form is not filled out and served and filed by parties. That was never done. A judge did it, and this lawyer, John David Ekpenyong, never even filed it with the courts. And yet, the trial coordinator's office, and I believe it was Salone French, who had to investigate and find her name out because I wanted to file a complaint, who scheduled the trial. And again, you know what? I wanted to take a second here. Because I could just already see, all these people that are just trying to railroad me, that have railroaded. They're going to point the finger, and and everyone else that's involved in all this police brutality case, these lawsuits. I'm not the problem. When you take an oath as a public servant and you swear you're gonna abide by the rules, you're gonna abide by code of ethic, you're gonna abide by being fair and being impartial, and you don't, and then you do this to somebody who had zero business ever being in the family court, let alone a trial, a rigged trial, and then you're gonna be surprised that I'm talking about these things. I'm not the problem. You're the problem. That's just facts. This isn't about a group of people conspiring to be against me. This is a group of people who work hand in hand for the government. So yes, they are kind of working together to kind of prevent certain things, And again, I had no business being in family court, and you've got a judge making all these statements that I'm going to get into that should have never even happened. This John David Ekpenyong, he keeps saying, I offered Mr. Dobson to get out of court, blah, blah, blah. No, you didn't. It was always stipulations. I'm going to get into the offers I sent out in August of 2022. And this lawyer wanted, what was it, $20,000? And then in June of 2023, wanted $27,000. And it wasn't until August of 2023 we got before Justice McLeod that told these two individuals, my ex and this lawyer, they had no case and they should rethink about it. Oh, and that's when all of a sudden they didn't want money from me. They didn't want to extort me anymore. And that's when they had all these stipulations in there. And I didn't want to abide by that. How about you just cancel this restraining order? A restraining order, I had no police history with my ex. No domestic violence. I never lived with her. I never had children with her. I never lived with her. She and her lawyer maliciously withheld the police report that she wrote March 27, 2022, when I had this illegal eviction that was orchestrated by John David Ekpenyong, who should have been a witness. That they admitted I was a tenant. I was paying rent, applying to the landlord-tenant board for an eviction application, and then they withheld that. Eviction application, right? So here's two crucial documents that were presented at the trial that the trial judge turned a blind eye to. That police report was on there, and so that was never done. We go to Rule 17.4, the purpose of case conferences, number 4A to H, the purpose of case conferences. I'm just going to put it up on the screen. 5, the purpose of settlement conference, A to H. Then we go to 17 subrule 11, the main rule that everyone loves to ignore in my case. The trial schedule endorsement form must be filled out, served, and filed by parties, not a judge, and be filed with the court, which was never done. So you see what they did to me? Do you see how they dealt with me? Telling me they let all these things slide. The restraining order application was never signed. Okay? And it's one of the rules. I thought it was 14.4. It's another rule that all documents must be signed. How many court staff clerks missed it, intentionally missed it? I went before 10 judges and they all missed it, right? We got costs. Where are we going to cost here? 17, 14. So here's another very important rule that was disregarded by the judges. Okay, 17 subrule 4, confirmation attendance. And then you got 14.1. Basically, you need to confirm your attendance. If you do not confirm your attendance, conferences shall not be held. Guess what? Every conference was held. What's the point of having rules and laws if parties aren't going to follow it, court staff isn't going to follow it, and judges aren't going to follow it? Okay? And don't be surprised I'm upset. And I'm speaking the truth. You know what? Because if the justice system wasn't so screwed up and unfair and rigged the way it was, and people getting their lives ruined in courts they had no business being in, and then we're going to have people that's going to be surprised. We shouldn't be surprised. I'm surprised there's not more people speaking up and talking about these things. Cost. 18. Let me see. No, cost. 18. So under 17. Or is it, sorry. I got 18 cost. Sorry. Rule 18 cost here. Cost shall be awarded at the conference unless a party was not prepared and did not serve documents. 18 months of unnecessary and prejudiced adjournments because this lawyer, John David Ekpenyong, was not prepared. You think I got $1? I didn't. I didn't get nothing. Here we go. 17 subrule 23, which is trial record. Trial record must be filed 20 days before the trial. You guys know that this trial record. So John David Ekpenyong lied to Justice Madsen on January 20th, 2024. Lied to this judge, told her that the trial was 3 days. And again, everything I say can be backed up by transcripts or evidence. So, you know what? Anyone wants to challenge me that I am misleading and lying and slandering anybody? I'm not. I'm telling the truth. I got nothing to hide I got nothing to hide. January 24th, 2024, excuse me. This lawyer scheduled it. The trial, I was told, on the 6th. You know, that's 12 days. 12 days. So again, another rule that was not followed by the trial judge. All of these things were brought up to Justice Michael Gibson, and you know, he said at the very beginning of that audio recording, again, I'd love the public to hear, is that we're here now, we're going to deal with it. Trial record was not filed on time. The trial schedule endorsement form was never filled out, served, and filed. You had a judge, Justice Martha Tweedie, who blocked out nearly 2 pages of transcripts, which tainted the case. Right there, that alone, this case should have been canceled. You've got a trial schedule, you got the restraining order application that was never signed. And what, we're here now, we're going to deal with it? How about we respect the rules that were put in place before all of us were even in these positions? We're not, you know, and I'm sorry. This is the problem I'm having with this judge, is that because he is the only judge in Ontario that came from the Canadian Armed Forces, let's be honest, everyone is too scared, okay? They're too scared to speak up and say this judge made a mistake. Well, this judge made many mistakes of the law and of facts, and that's just the truth. I'm pointing it all out. And I've tried to resolve this for forever, and they won't let me. So Rule 24, 5A, B, and C. Parties must behave. Ekpenyong didn't do that. Let me just read this. Decision on reasonableness. In deciding whether a party has behaved reasonably or unreasonably, the court shall determine a party's behavior in relation to issues from time they arose, including the party made an offer to settle. I made 2 offers to settle. August 2022, August 2020, multiple offers. I made 2 offers around August. They both rejected it, and this was all about extortion, asking me to pay money that they never paid. And how about this? Let's stop playing this game, this guessing game. Let's stop protecting those who have committed these crimes. Let's stop aiding and abetting these 2 individuals and these public servants who are all a part of this. And let's force John David Ekpenyong to do a financial assessment to prove what his client paid. Because he put down on paper, he charged his client, 50 hours for 4 affidavits? That's just fucking bullshit. Let's be honest. This court has allowed this lawyer to get away with perjury, submitting fraudulent documents, harassing me, stalking me, intimidating me, all this shit, you know? And there needs to be accountability. You know? B, the reasonableness of any offer made to party. C, any offer the party withdrew or failed to accept. This lawyer did not want to get out of this. And he's sitting there playing these psychotic games. Oh, Mr. Dobson had a chance to get out of this family court with no cost. No, but if you look at those stipulations, I didn't want to agree to nothing. Okay? I had no business being in family court. And Justice Martha Tweedie failed to apply these laws. This judge, Justice Martha Tweedie, failed to acknowledge all the rules I mentioned in Rule 2. None of the conferences were ever confirmed by this lawyer. She had to fill out his trial schedule endorsement form. And then you got this Canadian Judicial Council who refuses to investigate. You got the Minister of Justice who sends his foot soldiers from the Ministry of Attorney General to say, oh no, you got to go, you got to do this, you got to do that. Like, it's sickening. It is sickening what I have gone through and what I'm still going through. 24/7. Absent or unprepared. This lawyer sent students. He wasn't prepared for 18 months. 18 months. I lost 3 jobs. I lost 3 jobs because of this Kitchener-Waterloo courthouse and because of these judges. deleting endorsements, blocking out transcripts, blatantly lying on endorsements. For what? For what? All you guys did is give these two the impression they can get away with abusing the courts, and you took out one of the hardest electricians working in this friggin' province. That's all you guys did, contributing to these courts. You know, absent or unprepared, 18 months of prejudice adjournment, sending students, not filling out the trial record, the trial schedule endorsement form, not showing up. Bad faith, 2410. Acting in bad faith. Let me just read this exactly what it says. Sorry, I got bad faith, number 8. If a party has acted in bad faith, the court shall decide costs and full recovery basis and shall order the party to pay them immediately. John David Ekpenyong and his client often acted in bad faith, withholding a police report, withholding the landlord-tenant eviction application, lying to several judges, fraudulent documents they submitted, the perjury, telling the courts periodically I'm drug dealing, smuggling cocaine to the Bahamas. I was stalking my ex when she came down to Burlington and I saw her literally 1 kilometer from my house. And I brought this up to the court and they spun it all around. And I've shared in other videos. How does Mr. Dobson know she's in the city? 180,000 people. She goes to IKEA often. She runs a business. I live down the street. She drove by it. Okay. She's encroaching where I live. Okay. She admitted to frequenting 7 different businesses, all within a 5 to 10 kilometer radius from where I live. And I've got a lifetime restraining order against a woman who is tormenting me. She's abusing me. She's refusing to accept payment. She submitted a fraudulent document, her fraudulent home insurance fraud over $5,000. Yet nobody wants to do it. None of the police want to investigate. These police do not want to enforce the law. The Law Society does not want to reprimand lawyers acting bad. Okay? The prosecutors do not want to prosecute people who have clearly committed crimes. The judges have allowed these people to get away with this. It's crazy. It's like a friggin' movie I'm living. You know? It's like, it's one of those movies, you know? It's crazy. You know, I was unlawfully dragged to family court and forced into a rigged trial where judges, court staff ignored the rules and the law and allowed a psychotic lawyer and an unhinged ex-girlfriend abuse me for 3 years, and they're still abusing me. Justice Tweedie caused unnecessary and prejudiced adjournments for almost 2 years. First appearance, these two never showed up. Justice Tweedie was in her chambers for what, 40 minutes, was it? 30 minutes, 40 minutes? And then they accommodated these two with a Zoom link. They sent students, they accepted unsigned, the court accepted unsigned, uncommissioned documents. This judge filled out the applicant's trial schedule endorsement form. This judge refused the audio recording. She gave me bogus reasons that don't even exist in this thing she referenced. She blocked out nearly 2 pages of transcripts. Rule 17, Subrule 11. Excuse me. Parties must fill out the TSEF, not a judge. What does the Canadian Judicial Council say? Judges must make decisions off of evidence and facts. That wasn't done, okay? Judges must remain impartial. When a judge has to fill out one of the main documents in an applicant's forms, it is no longer impartial and it is now tainted, okay? John David Ekpenyong. You guys can see what I've prepared. I've got this whole thing prepared. Really, I want to improvise. I just want to speak from the top, off the top, and I can do that. But I want to make sure I cover everything. So that's what I'm doing. John David Ekpenyong had the judge do his job, then never filed the trial schedule endorsement form. January 25th, speak to before Justice Madsen. I waited 3 hours in an electrical room because John David Ekpenyong never showed up. And this was like a huge thing to me, losing my job to that big arena, downtown Toronto, my dream job. that I also brought up to Justice Gibson, and when he asked me about, oh, how could a restraining order affect me? It can affect my employment. What does he do? Gives me a maximum distance restraining order, lifetime. Gives me a permanent one, and because I peed behind a shed and just made statements that were untrue. I'm sorry. That is the truth. There are many statements on these endorsements that are untrue. They're intentionally misleading. And I have the evidence to prove that they just railroaded me and they abused their powers. And I went before this court of appeal. And all they did was just read the endorsements. They didn't even read why I was going before, and I'm going to get into that. Yeah, February 6th. I was forced to go to this trial. The trial schedule endorsement form was never filed, never served. The trial record was not served within 20 days. The application was never signed. And these two people, this applicant and a lawyer, rejected offers. And this was all brought up to the trial judge. And he said, we're here now, we're going to deal with it. Honestly, I just feel like it was already premeditated, the way it was handled, the trial. And that's why the public needs to hear these audio recordings from this trial. And I need to figure out a way to get permission from the courts and from this judge, because if they have nothing to hide, then it's in the public's best interest that they hear the trial, what was heard. And I have them on my computer. This judge did not want to give them to me. But once I said, I need them for my appeal, I was told, you don't even have to pay for them. And that's when I got railroaded with a $60,000 fraudulent court order cost to pay. All these issues were brought up before Justice Michael Gibson. And he said, we're here now, we're going to deal with it. Some important information I want you guys to know is that my ex, in this case, she recently dealt with a high-profile divorce case in the same court that lasted maybe 3 to 4 years. She's receiving over, $4,000 or $5,000 a month in support or more. She runs a business. She's good at balancing the books. I helped her out many times on her jobs. Always paid cash with her workers. She made a fraudulent home insurance claim, okay? She claimed $10,000 in damage that she refused to show the courts and that these judges refused her to present. She showed one page out of a 12-page booklet from her home insurance. I broke a $500 door. She and her lawyer on an affidavit said she paid $5,000 for the block fee. I lost a 2-day trial. They asked for $160,000. The trial judge entertained this fraudulent bill and orders me to pay $60,000. So let's look at this. It starts off with a fraudulent home insurance bill. Okay, she pays a $1,000 deductible, claims $10,000 in damage. I broke a $500 door. Her home insurance, traveler's insurance, paid her $9,000. For what? What did she get paid for? I never damaged any other things, and if they did, they should be forced to say what they showed. The Cambridge police, I spoke to a supervisor there. She refused to have her officers investigate this. This is home insurance over fraud, and it's in the public's best interest to know that. They admitted to paying $7,000 in legal fees. They tried to extort me in August 2022, $20,000. They tried to extort me in June of 2023 for $27,000. They admitted to paying $7,000. I lost a 2-day rigged trial. They asked me for $15,000. Okay, that is an offer, an email that I haven't shown in any of the videos. I'm going to do my best to find that email and share it with you guys. The lawyer, I asked for $15,000. 3 years of dealing with hell with this court, losing 3 jobs. That's the least. This lawyer acting in bad faith, lying to judges. This lawyer then ignorantly and foolishly submits a $160,000 fraudulent bill to Justice Michael Gibson. I was like, holy shit, I can't believe it. What happened at the trial, what happened with that endorsement, I'm like, I think this judge is going to give into it. He entertains that bill, orders me to pay $60,000. So you guys see what happened here? She pays $1,000 deductible. She gets $9,000. She's got $9,000. She pays her lawyer $7,000. She's still up $2,000. She gets awarded $60,000. She got awarded $62,000 in fraudulent bills. When are we going to wake up and investigate this stuff? These judges refuse to do it. The police refuse to do it. The Law Society refuses to do it. The Canadian Judicial Council refuses to do it. The top prosecutor the prosecutor's office stated the charges. The top prosecutor in Kitchener refusing to answer my emails about investigating this. We got the Minister of Justice who refuses to talk to me about these things. 7 bodies, okay? Judges blocking endorsements, filling out, deleting endorsements. That's forgery. That's corruption. Blocking out transcripts. That's covering up a major misconduct. Blatantly lying on endorsements that can't be backed up by evidence. That is corruption. So I can confidently say I am dealing with a major corruption case. Okay? At this trial, I went up against 6 people. A crooked lawyer, 2 lying witnesses, the Waterloo Region Police legal representative, who I subpoenaed 2 officers who wrote that report. An ex-girlfriend I was never married with, never had kids, never lived with, withheld the police report. I was renting her basement, and withheld the landlord-tenant eviction application. That all points to the living situation that I was not a spouse. I did not cohabitate. I was not a common law. Like Justice Gibson put it all on his endorsement. It just makes me sick to my stomach that I gotta make these videos and get this stuff off my chest because public servants don't want to be honest. They want to take money from taxpayers and then do this to people. And then no one's really got the balls to speak up about it in a factual and an honest, truthful, calm manner. I'm trying to be calm. I'm upset. And a judge, the 6 people, including a judge, a former military judge, only judge currently serving on the Ontario Superior Court. His judicial experience is entirely from the Canadian Armed Forces and military justice system. That's why nobody wants to touch this case. And that's why I'm pretty sure they assigned this judge to this trial so he could railroad me into space and nobody would question it, right? Because judges don't make mistakes, right? Judges don't make errors of facts, right? Judges don't make errors of law, right? No, wrong. Because that's what happened in my case. Okay? So don't look at me and don't judge me like, well, I am. You can say I'm crazy. I'm not. I'm frustrated. I'm upset. But I'm not wrong for doing this. It's just it's insane, but it's incredible at the same time what these people have gotten away with. Okay, so Justice Michael Gibson, he's a local senior judge that no one will question him, which was a clear issue at the Court of Appeal before Justice Lisa Favreau. She would not touch the appeal after seeing Justice Gibson's name on the endorsement. And I'll be getting fully into the appeal experience before the Court of Appeal. This judge railroaded me into space by providing intentional contradictive statements on his endorsements. This judge wrote on his endorsement, I emailed that I was not a tenant, I breached a temporary restraining order. They never happened. I showed this judge my phone call histories. At the trial, my ex admitted to never answering the phone. So she staged these calls. Oh, all these private phone calls. It must be from Mr. Dobson. It's only Mr. Dobson or the police. I want nothing to do with this woman. They're trying to portray me and gaslight to be this person I'm not. I showed this judge all my phone records on the dates that these alleged phone calls happened. I didn't make these calls. And on top of that, she admitted that I didn't make those calls. Yet this judge said I made those calls. This judge said I emailed her. I've shared it in a previous video. I'll share it again. She emailed herself. Did the judge even look at the email? She's got one email here, another email here, and then she's got a body of an email that I had sent to her lawyer. She copied and pasted an email, slapped it together, and told the court that I emailed her. And the judge said I did. Telling me I was not a tenant? I was a tenant. I moved in on December 10th, 2022. On December 9th, 2022, Katarina Bornerick lived there, whose mother, Kim Bornerick, was a witness at this trial, who was caught reading notes from a notepad. She lied, said her daughter never rented the basement. And then she admitted her daughter did live there for 6 months, knowing it was a year. She admitted this lawyer coached her the following day. And that's what I said. John David Ekpenyong was like, oh my God, I can't believe you just said that. You just admitted that. They rigged it. They had to cheat to get through this. And then they, I was living at 1139 Cook Boulevard in Burlington. I was supposed to stay in that complex. And then you had that greedy realtor who wanted my real estate agent's commission. And if I didn't pay, she wouldn't present my offer. You can see it in that video with the landlord-tenant board where Robert Pache told me to shut up, answer the questions. John David Ekpenyong never even filed any materials 2 days. They caused all the, 2 hearings. We had to go to 3 hearings where the witnesses got that landlord-tenant, the 3 of them, got caught lying. What about Mark Van Loven at this family court trial who got caught lying, made all those ridiculous statements? He witnessed 100 harassing text messages, but when asked to give one example, he couldn't because he lied. He lied under oath. Kim lied under oath. My ex lied under oath. John David Ekpenyong submitted fraudulent documents, lied under oath. This judge said that, called me a common law spouse. Said that I moved back in. You know a spouse is a husband or a wife? I was never married to this woman. Okay? Common law in Ontario is 3 years. We've got the top judge calling me a common law, and you're telling me these courts don't know what a common law is? I never lived with this woman ever. Almost 25 years older than me. You guys know what this was about. Okay? I met her in 2018? Okay? And we just didn't mesh together. Okay? We didn't mesh together. And I shouldn't even entertain this, but you know what? No business ever being in family court. No business. So this appeal judge wasn't hearing it. Yeah, witnesses got caught lying. Landlord-tenant witnesses got caught. I'll be doing a whole video on that, and every bit of evidence I got, the 5 witnesses who got caught lying under oath. Landlord-tenant board knew it, the family law knew it, and they still railroaded me. The trial judge ran the trial with no signed application. Trial schedule endorsement form wasn't filed. Trial record was served 12 days before. The trial was about 9 to 10 hours. I spoke for about 1.5 hours, almost 3 hours in breaks. And I remember that there was never any consideration to me. It was all about when the applicant and the judge. It was pretty much like, again, if you guys need to hear this audio recording, and they don't want you guys to hear that because everything I'm saying is the truth. There's no children involved. Why can't the public hear these audio recordings? Because it's going to expose everything that I'm saying is the truth. Justice said, 3 hours and breaks. The rest, John David Ekpenyong rambled on. Justice Gibson told this lawyer to stop asking repetitive questions. This judge, I may have it written down here, but this judge gave shit to Ekpenyong. He lost it on John David Ekpenyong because he submitted multiple documents that were commissioned and unsigned. And one of the documents that was commissioned and unsigned was the document admitting to all these phony payments, including a $7,000, this was the right one. The whole divisional court thing, This bozo put on paper that his client paid him $11,000 for the divisional court appeal. But guess what? 2 years later, when I lost that rigged divisional court hearing, all right, the one that I had to wait a year when they were given strict 60 days, the one where Justice Braid went behind our backs and deleted a 10-page endorsement down to 1, which any one of us in the public, if we would have been caught doing that, we would be doing a penitentiary bid. You can serve up to 10 years, but yet judges can do it, right? I guess they're immune to the law, because I think that tainted my appeal, my divisional court appeal for the landlord-tenant decision. It's just been nothing but a shit show. And I'm upset, obviously. Yeah, this lawyer admitted, this judge gave shit to Ekpenyong for admitting on this document that they submitted unsigned and commissioned. And there's several of them. And they admitted to paying $7,000. But yet, this same judge entertained a $160,000 bill that was never paid, that the Law Society doesn't want to question, because nobody wants to question, this judge's endorsement, where there's clearly many errors of laws and facts. And this Court of Appeal didn't want to hear it. And this is the route I got to go, that I don't want to go, that I'm going to go. Yeah. Yeah, the endorsement's a public document. It's uncannily, and it's nothing but it's misleading. It's slander. It's calling me rigorous, calling me a scorched earth litigant, sending hominin attacks. None of these things happen. And if they did, it was because I'm in a court I had no business being in, let alone a trial that already had that pretty much a predetermined outcome. Because if you listen to the audio recording, if you look at my materials I submitted, if you look at their materials, like, come on, this lawyer didn't even know how to reference any of his evidence. They're sitting there, he doesn't know. You know, if you guys know a family court or case lines, it'll say like master, page, something. This lawyer didn't know how to do any of that. He's like, rambled on for almost friggin' 8 hours. 6 hours. It was like 10 hours, 2 full days. Trial was 10 hours. The trial felt like it was more. Felt like it was like 16 hours. This lawyer rambled on for like 8 to 10 hours. Justice Gibson knew that John David Ekpenyong admitted he only charged his client $7,000, and then he entertained that fraudulent bill. I'm sorry, guys. I'm just getting into all this background information before I get into this Court of Appeal. Apologize for rambling on. I don't like making these videos, but it's eating me up every day. What I went through, the abuse I took from this Kitchener-Waterloo courthouse, and what this lawyer continues to get away with. Will not let me make payments. He's driving me into bankruptcy, him and his client. And I'm gonna be getting into a video of all these psychotic emails sent to me all hours of the night, threatening, harassing, stalking me. This guy hired a private investigator for what? So let me make payments. I thought Justice Gibson was going to call John David Ekpenyong out on his insanely and obvious fraudulent bill, but instead he entertained it. Made some pretty wild statements on his endorsement, 10, 11, 12, and 7. I'll put those up. I requested for $15,000, which I will share. And I reference rules 24, 4, 5, ABC, 7, and 10. It was... it's crazy when I think about everything that happened to me. Justice Gibson completely ignored these rules. Instead, he went straight to Rule 1, 24.1. I can't believe Justice Gibson entertained that fraudulent bill and thought it would be some donkey and not question his fraudulent, John David Ekpenyong's fraudulent and criminal phony legal bill. You know, because that's what it was, basically. I don't think anyone anticipated that I would be doing these videos. To be honest, neither did I. I don't want to be making these videos. They honestly make me sick doing these videos, rehashing everything. Because there's no accountability. The corruption I'm dealing with all the government bodies and public servants that are all collectively helping each other to try to put up barriers of litigation. That's all this is. August 2022, John David Ekpenyong refused 2 of my offers to settle, one matching his offer he sent 2 weeks prior, unless I gave him the $20,000 extortion. And then in June 2023, they requested $27,000. It's just, that's why I say I believe I'm dealing with Canada's most corrupted family court case in Canadian history. Okay. Jeez. The appeal. So now we're at the appeal. Another rigged proceeding, predetermined decision, went before Justice Lisa G. Favreau on September 23rd, 2024. Obvious pattern of abuse to self-represent litigants. And again, I'd love to share the audio recordings of that appeal, just so you guys can actually get your own opinion of what really happened, instead of these written endorsements like this one that I'll be getting into from the Court of Appeal and Justice Gibson's that I clearly disagree with. And it's not about whether I disagree, who cares what I feel? It's about the law that was ignored, the laws that were ignored. It was the facts that were ignored. Making statements, calling me saying we cohabitated, saying I moved back in, calling me a spouse, calling me a common law when none of these things ever happened. John David Ekpenyong submitted his materials to the Court of Appeal 45 minutes before. 10 minutes before the hearing, his materials were accepted, which were unsigned and uncommissioned. And it's interesting because when I was doing some research on Canley, John David Ekpenyong went before Justice Lisa Favreau on October 1st, 2019. So this wasn't the first time Ekpenyong went in front of this judge. There's a 4-part test in the Court of Appeal. Whether the appellant formed an intention to appeal within the relevant 30 days, which I did, 30 days with the divisional court. The length and explanation for delay. I filed it 30 days with the divisional court. I was told to go to the Court of Appeal. And because I was working 6 days a week, 10-hour days out in Windsor, it took me 120 days to get when I got in front of that judge, when I finally got in front of the judge. So if you look at when my materials were accepted, when I got in front of the judge, it was like 100 days, which isn't too bad for a self-represent litigant. Is it prejudice, not N, but prejudice to the respondent? They never said it would be. And why would it be? And then number 4, the merits of the appeal. I had no business being in family court. Justice Tweedie, you heard what she did. Justice Gibson, you heard what he said and he did. The $160,000 fraudulent bill that nobody wants to question. This judge ran me down and ran my materials down. This was an easy decision if this judge was truly impartial. But this judge refuses to overstep Justice Gibson's decision. I'm pretty sure she's seen this judge's name and she knows his credentials. Justice Tweedie tainted my case when she filled out that trial schedule endorsement form, when she blocked out the transcripts. John David Ekpenyong never filed it. Restraining order application was commissioned and not signed by his client. And this happened 6 times dealing with John David Ekpenyong. You know it's a major, it's frowned upon with lawyers commissioning documents without their client's signature. You know none of these judges ever truly scolded him. You know how many times the lawyer was caught lying to judges, called out at hearings, how much evidence I provided. They never even did anything. Court staff, judges all turned a blind eye to the facts, the laws. I was never married, never had kids, did not live with the applicant. There was no police ever involved. There was no domestic violence ever. They withheld the police report confirming the living situation. They withheld the landlord-tenant eviction application. Why am I in family court? Justice Gibson made obvious errors of laws and facts, calling us common law spouses, moving back in. She had reason to fear for her life because I spilled garbage and peed behind her shed. Really? I'm sorry, but Justice Gibson blatantly provided misleading and contradictory statements on his endorsement. I've said it before. He said I called her, I emailed her, I breached my temporary restraining order. I was not a tenant. None of these things are true. I never breached my temporary restraining order. I was never charged. I was never warned by anybody. That is not a breach. I presented my case just like I did at the family court trial. It was a no-brainer. But because of this court corruption, I never had a fair chance. This judge, okay, so as we presented our case, Justice Fraver asked for cost. If I win the motion, what would I ask for costs? So I said, hey, I took time off work. I filed my materials. You know, if you would award $1,500, I'd be happy with that. She kind of cut me off. I actually said I remember counting up the 500, 750. She said, okay. She cut me off, thinking I was asking for $750 because she already had her decision made up. And again, I'd love the public to hear these audio recordings of this Court of Appeal to see how I was mistreated. So she let me continue on. I went to the $1,500 request, which is very reasonable. And then she went on to, she said, okay. She went to John David Ekpenyong, asked him, what's he asking for? Right off the top, he says $7,000. She says, for what? What do you want $7,000 for? This is a lawyer with a license, doesn't even present any cost. John David Ekpenyong is a pathological liar. He has been caught on record and in written materials blatantly lying well over 20 times. Okay? When I say this lawyer is a pathological liar, he is. Okay? John David Ekpenyong told Justice Favreau he spent 30 hours on his materials, and that is absolutely bullshit. Okay? How many times is this lawyer going to get away with lying to judges? Okay? He wrote a 2-page factum. He wrote a 6 to 7 page affidavit telling this judge he spent 30 hours on that. This is how I'll tell you guys, this is how I'm catching this guy lying again. Okay? He emailed the Court of Appeal on September 20th, 2024 at 4:33 about filing his materials, and if the judge will accept it, he's going to send it the day of. What kind of lawyer knows he's going to the Court of Appeal, doesn't prepare his materials? Okay? What kind of lawyer is getting ready for a family court trial, doesn't file his trial schedule endorsement form? What kind of lawyer commissions 6 documents without his client's signature? You know who? A lawyer who got his license out of a cereal box. A lawyer who needs to be investigated because I will put everything on the line. He cheated on his exam. He has no educational background, and I want to know he challenged the test. Okay? I feel like he's challenged the test. He took one of these prep exam course who gave him the answers. That is my guess. Until he can prove what he's done, that's what I'm saying. Right? He submitted his materials to me at 10 o'clock on a Sunday. 4:30 on a Friday, 10 o'clock on a Sunday. That's a 50-hour window. This piece of shit told the judge he spent 30 hours on his materials. A 2-page factum, a 7-page affidavit. Not even signed, not even commissioned. And this judge accepted his materials. And I'm going to get into an endorsement saying that how she never read them. But if you read along the lines, it sounds like she did. Okay? This is just some of the bullshit I'm dealing with. I'll show you the materials, how this guy lied to the Court of Appeal. I explained to this judge I filed with the Court of the Divisional Court. You know what? Yeah, let's get into Justice Fraver's endorsement. So A, the moving party seeks an extension of time to appeal the restraining order and the cost order. His materials focus primarily on his grounds of appeal. He has not filed an affidavit in support of his motion. So this is why part of the reason why she denied my appeal, because I didn't file an affidavit, and I didn't show proof that I filed with the divisional court. But if you guys look at my materials, a real lawyer who actually honestly studied probably would have charged a true $160,000. Okay? In response to the motion, my ex filed an affidavit that was not sworn or commissioned. The attachments to the affidavit are primarily court documents and as such are properly before me without an affidavit. I have not considered the contents in Miss Blank's unsworn affidavit. I don't believe that. I don't believe that this judge read the materials, because the signatures are on the back. And the way this judge dealt with me and what she wrote, I'm sorry, I do not believe that this judge did not review these materials. This judge comments on John David Ekpenyong's materials on the last paragraph. So she does comment. Is it F? Let's go to F maybe. Yeah. No, it's somewhere in here that she comments on his materials. Let's go to C. In the absence of any affidavit, Mr. Dobson, there is no evidence that he intended to appeal the restraining order and cost orders with the appeal period, nor is there any explanation for his delay. While Mr. Dobson says that he originally filed his appeal in the divisional court, he has provided no evidence in support of contention. In fact, he advised during the argument all his email exchanges with the divisional court had been deleted and provided no evidence to support this statement. Additionally, there is no evidence to explain the significant delay the delay of his motions materials were not filed with the court. I already provided this explanation to this judge about my work schedule. And I did find it. Yes, I did delete all the emails because I had no space dealing with all this crap going back and forth for nothing. But I did have it in a PDF where I did file it with the divisional court. And that's where Ingrid from the divisional court told me I had to go to the Court of Appeal. D. Even if there was evidence to address these issues, there is no merit to the proposed appeal. The trial judge made factual findings that Mr. Dobson and so-and-so lived together for various periods of times as required for restraining order section 46 of the Family Law Act. The trial judge also was satisfied Mr. Dobson persistently harassed so-and-so and that she therefore had legitimate fear for her safety. These findings were based in the part that a judge's assessment that Mr. Dobson was not a credible witness. These are factual findings to the court owes to deference. Nothing in record provided by Mr. Dobson on this motion suggests the trial made any palpable or overriding errors. Yeah, I did. This judge didn't read my materials. We never lived together. I was not persistently harassing. I was a credible witness. Her witnesses lied. Nothing suggests the trial judge made errors. He did. He's saying that this is ridiculous. This honestly makes me sick to my stomach reading this, knowing what happened at that family court trial, knowing what I presented, and knowing the bullshit that I'm going through. It's not just because what a judge puts on paper, it's the truth, and there's no errors. It's wrong. Wrong. This judge, Justice Gibson, did not like me. And he did not like me because of that audio recording where my ex went all freaking ballistic on me, got me upset, and then started recording me. You know that most judges in a family court trial who are truly impartial do not accept partial recordings? No, there's no leading up to how this recording happened. And I wrote that judge a letter that, it's not normal to do that, but I was clearly upset about his endorsement. The judge did not make factual findings. No, he didn't. We did not live together for various periods of time. We never lived together. This is just bullshit. It is. It's just bullshit. I'm not being butthurt. I'm not being whiny. I know it sounds like it, but it's just insane what these guys did to me. Oh, and she had legitimate fears for her safety because I peed behind a shed and because I spewed trash one day because I missed the garbage. This is the bullshit that they're doing to people. Here we go. Let's get into E. There's also appears to be no merit to proposed appeal from the cost order. To appeal cost order, Mr. Dobson would have to meet the high test to obtain leave of court. Mr. Dobson would have to show that the trial judge made error in principle or that the cost decision was plainly wrong. During an argument before, Dobson suggested that the bill of costs submitted by counsel for his client was fraudulent without any evidentiary foundation for allegation. In any event, the trial judge significantly reduced the cost sought. It's hard to see how Mr. Dobson met the high bar for obtaining leave, if granted, how he could succeed in appeal. This is the bullshit I'm talking about. This judge, all she did was take Justice Gibson's side. Okay? He admitted. See, this judge never read my materials. This judge already formed an opinion before I went before her. That's just the bottom line. Okay? I'm not sitting here bashing anybody for no reason. If the judge took the time to read my materials, she would see that Justice Gibson obviously made errors of law and obviously made errors of facts. It was a fraudulent bill. This is what I'm talking about. These judges and everybody wants to keep playing this guessing game about this fraudulent bill. How about we stop playing this guessing game and just get them to show proof of payment instead of making these type of statements? And then here we go. Let's point the finger at me like I'm the bad guy because I'm calling out bullshit. I'm calling out fraud. I'm calling out perjury. I'm trying to get help from these courts who refuse to help, who want to sit there and collect a nice little $200,000, $300,000, $400,000 a year paycheck, $5,000, $6,000 a week, and do this crap to people, and then be surprised people are upset. F. Finally, the applicant did not provide any evidence of prejudice. If this appeal is allowed to proceed, it is evident from the trial judge's reasons and even from the materials provided by Mr. Dobson himself that Mr. Dobson has engaged in a pattern of harassment with Miss So-and-so. The proceedings have included ongoing attacks on Miss and her counsel. The trial judge described as a scorched earth litigant tactics. These are hallmarks of vexatious proceeding. To allow Mr. Dobson to proceed tactics his appeal is simply to allow him to prolong his conduct. Let's just quit the fucking bullshit. Straight up. Let's just quit the fucking bullshit, okay? I never belonged in family court, okay? This is another perfect example of judges acting non-impartial. All she did was take this judge's side who straight up lied on his endorsement, making statements that cannot be backed up by any evidence. I want the public to know what happened to me. I have nothing to hide. This is fucking bullshit. This and every other endorsement from this family court proves how broken, corrupted, and biased our justice system is. To overstep Justice Gibson's, his rulings that he lied on. And that's the honest truth. And they do not want to give me a voice. Okay? This is bullshit. This judge said, they never said I was prejudiced, but she said I would be if you allowed it. I had no fucking business being in this court. And they just want to suppress me and keep me down and railroad one of the hardest working fucking blue collars that's courthouse has ever seen. I had to walk away from $150,000 job a year because of this fucking lawyer and what these courts allowed him to get away with. And then you're going to be surprised that I'm upset? I'm not the problem. These public servants are. And there needs to be accountability. The Canadian Judicial Council refuses to do anything. This Minister of Justice refuses to do anything. These prosecutors refuse to do anything. These judges refuse to do anything. These police refuse to do anything. This Canadian Judicial Council refuses to do anything. This is what I'm up against. Are they all conspiring against me? No. But they're working together to protect Canada's only military judge who straight up provided misleading and contradictory statements because I believe he didn't like me. Because of the audio recording and that letter I sent to him. Let's get down to the nitty gritty. Just fix this. They won't fix it. Okay? Conclusion to this video. Justice Gibson made obvious and intentional errors of laws and facts. I never cohabitated. I never was a common law. I was not a spouse. Saying I was irrigorous, telling me I was acting bad, scorched earth litigant tactics, saying we engaged in ad hominem attacks, restraining order application never signed, trial schedule endorsement form never filled out, served, and filed. Justice Martha Tweedie thought she was going to get away with potentially Kitchener-Waterloo's biggest misconduct by blocking out transcripts and not releasing audio recordings, which the public has the right to. This judge said he didn't believe me. This judge said she didn't believe me when the applicant's witnesses got caught lying. Mark and Kim got caught lying, got caught reading notes from a notepad, made bogus statements, admitted to being coached. I had nothing but respect for this judge. And I knew going into that trial, he did serve in the Canadian Armed Forces. The public needs to hear these audio recordings because everything I say is the truth. And this judge gave shit to John David Ekpenyong for commissioning documents and admitted to paying only $7,000, not $160,000. They submitted that fraudulent bill of $160,000 that Kitchener's top judge entertained. And John David Ekpenyong's materials for the Court of Appeal were unsigned and uncommissioned. John David Ekpenyong has lied to several judges. He has submitted over $200,000 in fraudulent bills. This lawyer does not know what he's doing. He's got this piece of paper. He's taking this on personally. He refuses to accept payment plan. I've got a sick cat that I cannot pay for because of this fucking bullshit I'm dealing with. I love my animals. I love all animals. I want to help people. I want to help the less fortunate. I want to help women who are actually abused, women who are actually being in abusive relationships, not the bullshit they're saying that I did. Go ahead, use this against me and say, look at Mr. Dobson, he's upset. You think I'm up? If you're going to sit there and point the finger at me, you got rocks in your head, okay? Because I had no business being in family court. And what I have on these judges, okay, is very disturbing considering they all took an oath to act impartial and to do these things. And I want answers. I want answers. That's all I want. You know, this Court of Appeal, this whole thing was Justice Lisa Favreau, who John David Ekpenyong went before, who already had her mind made up, just like it seemed like Justice Gibson already had his mind made up, writing those things on endorsement, writing this crap on endorsement. This judge accepted this lawyer's materials unsigned, uncommissioned, 10 minutes before the hearing. They said it wasn't prejudice. This judge said it was prejudice. This judge just fed into what Justice Gibson said. Oh, he had factual findings of them living together. Common law. No, he didn't. Never once. A friggin' police report that was included in my material package showed that they withheld that police report, that they withheld that landlord-tenant eviction application. This is a fucking disgrace. These court proceedings that I got dragged into unlawfully, it's sickening. It is sickening reading these endorsements because I know the truth. And this is what they're doing. I'm dealing with Canada's most corrupted family court case in Canadian history, and I can prove multiple judges are in potentially serious misconduct and need to be investigated. But you got these corrupted screening officers over at the Canadian Judicial Council, which I'll be getting into a full video, who refuse, and maybe they're being coached, maybe they're being consulted with, that do not get these complaints to our judges. Because even if they do, look what the Law Society did to me. And I won't stop telling the truth. I will not stop telling the truth unless the courts do the right thing and fix what they did to me. If I had to claim bankruptcy because of this lawyer, it's going to fall on these courts for allowing it. trying to label me a fictitious litigant, this lawyer, throwing a application at my door, telling the courts on his affidavit that he saw me through the peephole when I was not home. Do you guys know that is not proper serving documents? You have to hand it to an adult. But there's Justice MacArthur, Justice Gibson, and then Justice Smith. All three of them I told this to, and they still allowed this bullshit application go to a motion. 100 days later, I'm still waiting for a response. This is why, a perfect reason why courtrooms need cameras. Why all recordings and transcripts need to be available public. Because look what happened to me. And look what they're covering up. And look how they're protecting each other. It's disgusting, the corruption I'm dealing with. And there needs to be accountability. And that's all I'm asking for. You want to be a public servant? You want to get paid almost $500,000 a year? Don't let your ego go to your head. Abide by your oath that you're going to act impartial. You're going to abide by the Canadian Judicial Council and the Judges Act, and you're going to handle cases by facts and by the law. Because that was not applied in my case. And I think it's very evident. I'm going to leave the video right there. And I've been procrastinating to do this. You can tell I don't want to be doing these videos. But I got to I want to get out to the public what happened to me. Because what this lawyer's doing to me, what these judges have allowed. Look what's happening with our country. We're in an affordability crisis, and this judge orders me to pay $60,000 knowing they only paid $7,000. No one wants to investigate. Public servants are ruining blue-collar lives. What a joke. Never married, no children, never lived together. Police report identified clearly that she admitted to this, that I was a tenant. An ex-girlfriend did a solid. Bullshit. This is corruption at its finest. And I'm going to leave the video with that. I want to thank you guys for watching this video. Let's talk about it. This is my experience with the Court of Appeal. If you guys are thinking about filing an appeal with the court, hopefully this video helped you guys out. And if you guys haven't already, please subscribe. Thank you for watching.